Hello everyone, welcome to another episode of our channel Law Point. This is Reenu Thomas, your host for this episode. Everyone likes to receive gifts. It generally brings a big smile on a person's face. It is a way in which the giver makes the recipient feel valued. But what if these gifts are of a very high monetary value, like a house, landed property, etc.? Are there any rules and regulations which needs to be followed? This will be explained in this episode by Mrs. Praseena Elizabeth Joseph, our advocate on record from Supreme Court of India. This is third in the series of property transfer. So let's watch this episode.
Gift is a voluntary transfer of movable or immovable property from the owner to the recipient. Now, movable property includes car, jewelry, motorcycle, etc. And immovable property includes house, landed property, etc. Now, in legal terminology, the giver of the gift is called the donor and the recipient is called donee. The donor or the giver of the gift must be of sound mind and he must be a major under the Indian Majority Act. That means he must have completed 18 years of age. So, it is clear that a minor under 18 years of age cannot become a giver of the gift, that is a donor, but he can be a donee or the recipient of the gift through his legal guardian. For a gift to be valid, the gift need to be offered by the donor and need to be accepted by the donee. This acceptance process is complete when the donee or the recipient receives or takes possession of the gifted property during the lifetime of the donor. Section 122 of the Transfer of Property Act deals with transfer of property through gift. Just like sale deed, gift deed need to be registered in accordance with the procedure prescribed in the Indian Registration Act at the Sub-Registrar's office where the gifted property is situated, following the due procedure. Now let's see what are the important clauses which you should know while drafting a gift deed. First of all, it is consideration. It should be clearly mentioned in the gift deed that the gift is made out of love and affection of the donor towards the donee, and there is no money part or monetary consideration in exchange. Secondly, the property to be gifted must be in existence and it should be in the possession of the donor. That means the donor cannot gift a property which he might get in the future. Thirdly, it must be clearly mentioned in the gift deed that this gift is made out of free will of the donor and there is no compulsion, pressure or threat to execute this gift deed. Fourthly, a detailed description of the gift is a must. That means the gift deed need to clearly specify the structure, address, shape, color, area, location, size, etc. of the gift depending on the nature of the gift. Fifthly, the gift deed must mention the acceptance of the donee towards the gift. Sixthly, the right of donee need to be mentioned clearly in the gift deed. That means the right to enjoy the gift peacefully, right to sell the property, gift the property, lease the property, mortgage the property, right to change the property, right to receive rent, profits from that property, etc. The seventh factor which need to be considered here is the liability of the donee. Here, if the gift value is more than 50,000 rupees, then the gift is liable for taxation under the head income from other sources which need to be paid by the donee. However, it is important to note herein that if this gift is received from any relatives or for donee's marriage or by will or inheritance or from any charitable organizations or trust, educational institutions, university, etc., then this is exempted from taxation. Eighthly, delivery of the gift, that is, taking possession of the gift from the donor by the donee. The execution of gift deed must be in the presence of two eyewitnesses and it need to contain their name and address. 10th important factor is revocation clause. This is an important clause in the gift deed wherein reserving the right of the donor to take back or revoke the gift on non-fulfillment of a condition prescribed in the gift deed. For example, the maintenance clause prescribed in the gift deed wherein the donee need to maintain the donor with a monthly amount of rupees so and so. Then on non-fulfillment of this condition by the donee, the donor has the right to revoke this gift deed and the property goes back to the donor. It is important to mention herein that this specific condition need to be expressly mentioned in the gift deed and need to be accepted by the donor and the donee while entering into the gift deed. Now the last and the most important part of a gift deed is the relationship between the donor and donee need to be clearly mentioned in the gift deed. If the donor and the donee are relatives like one's spouse, children, grandchildren, widow of a deceased son or immediate family member, then some states grant concession in the stamp duty while registering the gift deed. For example, in state of Tamil Nadu, if it is a gift to a family member, then the stamp duty is 1% of the market value, whereas if the gift is to a non-family member, then it is 7% of the market value. In state of Maharashtra, if it is a gift of a residential or agricultural property to a family member, then it is mere rupees 200 as stamp duty with 1% registration charges. And in state of Kerala, if the gift is to a family member, then it is 0.002% with 1% registration charges, and if the gift is to a non-family member, then the stamp duty is 8% of the market value with 2% registration charges. Thank you.
Thank you for watching. Meet you in the next episode. Till then, stay tuned.